Doing pretty darn good. How about yourself?
Okay, you enjoying the property vision?
I'll tell you, it's keeping me busy.
Way with organizing anything there?
Still working on it. It's a slower process than I'd anticipated, but it's going to be a sound and a sustainable process in the end. So
Okay,
it's teaching me patience.
gotcha.
Is this the only case that you have for today?
Yes,
Good.
that's right.
You can get Van Zandt County out of the way and focus on other things early on.
I have Nathan Sampson in the afternoon
Okay.
for a writ hearing, but this is the only one for Miss Walker is only for the morning. That's it.
Gotcha. Well, we appreciate you getting out here ahead of time and taking care of all the paperwork.
Yeah, I try to get all the paperwork done. In other counties, they won't accept the paperwork without the fingerprint on the judgment prior to court. And
Yes.
in Smith County, they'll do the judgment after. They won't accept the paperwork before. So just want to make it easier.
Thank you.
I didn't realize that we were going to have somebody at the jail this morning. So Shrav, I have no objection. I don't know what the court's plans are to taking up Mr. Sampson this morning. If the court can do that, just to save you the afternoon docket, whichever works for everybody else.
I think there was a pretty large docket for the morning. I think that's why they put it for the afternoon.
No, sir. From what I see, we've got 4 males after Ms. Walker here, but again, I don't know what judge and the rest of the court have scheduled for the morning, but.
Good morning.
Good morning, Your Honor.
Mr. Murray Leader, I was looking over the docket. I mean, a writ hearing is not going to last very long. I'm sure that we could do that this morning. I'm still waiting on other attorneys to arrive. So right now, I think I only have you and Mr. Wood here. I'm on the other attorneys. So if the jail can accommodate us, and as Ms. Heisel said, she doesn't mind, I certainly don't mind, and we can go ahead and get that done.
Judge, I would be fine with that. I had a witness that was going to appear by Zoom, Donna Featherston. After we complete the plea for Ms. Walker, can I just see if she'd be available this morning?
Sure, absolutely. And if not, that's okay. We can keep it as scheduled. But if you can move it and you want to move it, I'm fine with it as well.
Judge.
All right, Ms. Walker, if you'll step up, please, ma'am. All right. This is cause number CR 18231, State of Texas versus Georgie Marie Walker. Ms. Walker, if you will, please, ma'am, raise your right hand. I'm going to place you under oath. Ms. Walker, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. Ms. Walker, I have a few questions for you. You have had Mr. Shravnesh Muraliter appointed to you as your counsel. Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you have reviewed with him and that you have signed that you do not understand?
No, Your Honor.
Ms. Walker, as I look throughout the documents, I see what appears to be your signature in various spots on the paperwork. Let me see if I can show that to you. Is that your true and correct signature?
Yes, Your Honor.
And if this signature appears throughout various documents, do you swear that that is your true and correct signature and that you've only signed it once you understood everything that you read and signed?
Yes, Your Honor.
All right. Ms. Walker, have you ever been diagnosed with any type of mental condition?
Yes, Your Honor.
And what have you been diagnosed with?
Depression and bipolar.
And are you currently on medication for either one of those?
Yes, Your Honor.
And do you feel like that medication is assisting you in having rational thought and understanding?
Yes, Your Honor.
All right. Mr. Muraliter, do you believe Ms. Walker to be competent today?
Yes, Your Honor.
And Mr. Muraliter, is it your client's intention in this plea agreement today to plead true to all counts in the state's motion to adjudicate?
That's correct, Your Honor.
And does she waive the formal reading of the motion to adjudicate?
Yes.
All right, and my understanding of the plea agreement is Ms. Walker pleads true to the allegations, that the state recommends that her guilt be adjudicated, that she be convicted for abandoning or endangering a child with criminal negligence, that her community supervision be revoked, that the court assess 15 months punishment and order her to pay the balance of her financial obligations, which includes fine, court costs, and that she would receive 177 days credit for the time that she has spent in jail towards this cause. And I believe that there's also a dismissal in another cause, CR 2416. I'm not sure what that charge is, but is that your understanding of the agreement?
That is, Your Honor.
Right,
And
yeah.
the charge of,
Oh, sorry, Rob. Yes, Judge, and I will be submitting that motion to dismiss. It is an aggravated assault with a deadly weapon charge that was picked up while Ms. Walker was on probation. However, it is not contained in the allegations of the MTA.
Okay, and I think that I may have that. I think Ms. has been signed by Mr. Kane, I believe, right?
Oh, great, Judge. Thank you. Okay.
Is that the correct case we're talking about? It just
CR 2416. Yes, Judge. That's
Okay.
correct.
Okay.
and Judge, that is our understanding of the agreement.
Thank you, Mr. Merlader. Okay, so Ms. Walker, you appeared before the court on January 22nd, 2019. You pled guilty to abandoning or endangering a child with criminal negligence. The court reviewed the evidence on that date, found that there was enough evidence to convict you. However, the court deferred a finding of guilt and placed you on community supervision as you reached a plea agreement with the state. And it was during that term of your community supervision that the state filed its motion to adjudicate, and they alleged in 9 separate counts ways that you violated your community supervision. At this time, Ms. Walker, I would ask you, how do you plead to counts 1, 2, 3, 4, 5, 6, 7, 8, and 9? Are those counts true or not true?
True.
And Ms. Walker, are you telling me that those counts are true because in fact they are true and you're not just telling me that so you can get some kind of plea agreement?
They are true, Your Honor.
And Ms. Walker, has anyone threatened you or forced you or made you feel like you had to plead true to any of these counts?
No, Your Honor.
All right, the court will accept Ms. Walker's plea of true to each count. And Mr. Merlader, is there any objection to the admission of the defendant's waiver of rights and plea of true as State's Exhibit A?
No objection, Your Honor.
All right, court admits State's Exhibit A into evidence and takes judicial notice of Ms. Walker's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
Yes, Your Honor, just 2 things. Your Honor, I've counseled Ms. Walker on the state jail diligent participation program. She is getting 177 days credit towards her sentence. So she approximately has 9 months left on her sentence. With the pandemic, there have been several people in the jail who are currently waiting on a state jail sentence. We completed a plea for a defendant named Kelly Coffey back in mid-October, and she's still waiting to go to state jail. In the event that she's not able to participate in the state jail diligent participation program, I've asked her to write to the court if the court would give her credit, if that was even possible. If she still remains here, 6 months or longer. I just wanted the court to be aware of that. And Ms. Walker did tell me that she has 1 incident from the jail when she was not on her medications. But since then, she has been put on Zoloft, Seroquel, and melatonin for her diagnosed mental conditions. And she has had no disciplinary issues, and she wishes to participate in any kind of programs the jail might offer if she's not sent to state jail.
I can't speak to, obviously the state jail diligent participation program is a program set up through TDCJ. I don't believe that the Van Zandt County Jail has any such program. However, if the jail seeks to enroll her in anything that they do provide that I'm unaware of, and Ms. Walker asks for any kind of diligent participation credit towards her sentence and the jail provides supporting documentation and joins her in that, then I will certainly consider that. I'm not sure that I think that would have to come back via motion to the court as the convicting court to commute the sentence, whereas the diligent participation is a practice and method set up through TDCJ that's statutory. So I don't think it's as easy as just her writing me and me giving her the same type of consideration while she's at state jail, because there's not a statute that allows me to do that under a diligent participation in a county jail. However, if she participates and the jail, joins in asking for some kind of commuted sentence, and there's a motion filed and she's brought back before the court under, the rules, then I'll certainly consider that for sure. And if she goes, and just for her knowledge, if she does get transported to state jail, then the way that diligent participation works, oftentimes I get letters asking me to grant that. But statutorily, the way that works is that TDCJ, once the offender is processed in and they begin their sentence and they enroll in their programs, and that triggers TDCJ's mechanisms for notifying the court under certain timelines. And then I get notified electronically that certain offenders are eligible and how much time they're eligible. And then I'm given an option to decide between 0 days and whatever days are presented to me. So that's how that works from the court's side. Okay. So if she's not sent down to TDCJ, then that is something that, will have to be brought back to the court's attention.
Thank you, Your Honor.
All right, Ms. Walker, do you have any questions?
No, Your Honor.
Okay. All right, Ms. Walker, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. You've already been fingerprinted, so you'll be returned to custody, and I wish you luck and hope that when you get out, you're able to become a productive member of our society and stay out of prison. Okay?
Yes, Your Honor. Thank you.
You're welcome. All right, Mr. Merleader, if you want to, you can just log back into the waiting room if you get a hold of your witness and you want to go forward. If you don't log back in, then I'll know that we'll just proceed this afternoon.
Yes, Your Honor. I'll notify Ms. Taberham as well.
Okay, and I'll tell you that this afternoon, I'm going to be a little bit delayed coming back for the 1:30 docket, so it'll probably be closer to 2 before I can take the bench, because I've got a commitment that I have to attend to with one of my kids, a medical doctor dental appointment. So that's probably going to delay me a little bit, and so I'm probably going to take lunch later and try to work more in the morning and handle that during my lunch hour. So just so that you're aware, it'd probably be at least 2 before I can take the bench. So if you need to arrange your witness accordingly.
Thank you, Your Honor.
All right. Thank you, Mr. Merleader.
All right, good luck, Ms. Walker.
Thank you.
Hey, this is Erin up in the courtroom.
Good morning, Mr. Head. Can you see and hear me okay?
Yes, sir, Your Honor, I can.
All right, Mr. Hankins, I'm going to prompt you to unmute. If you'll just click. Okay, there we go.
Good morning, Judge. Good morning.
Good
sir.
morning. Can you see and hear Mr. Head, your attorney, okay?
Yes, sir, I can.
Okay. All right, this is cause number CR 20121, State versus Quincy Lamar Hankins. Show that we were set today for an evidentiary hearing, but I didn't see a contested motion on file. Is that correct, Mr. Head?
Your Honor, I'll have to check. I believe we have filed one, but we had agreed that we would not have a hearing today. We have been discussing some new potential resolutions, and we are hopeful that we will be able to get the case worked out. But we did prepare one, and I thought we had it e-filed, but it may have been rejected for some reason. I'll check on that.
And Judge, I will just say that the state checked either late last week or early this week, and there did not appear to be one in the file. So I let Mr. Head know we would have an objection to having a hearing today. Obviously, we weren't served timely, but we are discussing this case. And if Mr. Head has that on file or can check a reset date, we will either have the case worked out or have a contested hearing at that point, provided notice.
Okay. And Mr. Head, what I'm going to do is I'm going to show you the clerk's screen here. And so this is what the court reviewed, and I didn't see any motions filed. So what we'll do is based on that, the court will set Mr. Hankins for a docket call hearing. And if you file a motion, then I'll let you argue and give the state a chance since it wasn't filed timely. And we'll set this for docket call on, are you available on March 11th?
Yes, sir, Your Honor, that'd be fine.
Any objection from the state in setting it for docket call on March 11th?
No, Your Honor.
Okay. So we'll plan to appear via Zoom that day as well, unless there's some kind of resolution that requires us to appear in person.
Yes, sir, and I'll get with Mr. Hankins regarding the new offer and then get back with the state as well.
Okay, so that'll be at 9 a.m. on March 11th. And with that, Mr. Hankins, you're free to go.
All right, thank you, sir. Have a great day.
You're welcome.
Thank you,
too.
Your Honor.
You're welcome. All right, let me bring Ms. Porter in.
Okay. Thank you so much, sir. Have a great day. Yes, sir.
Morning, Mr. Wood.
Morning, Judge. How are you?
Doing fine. How's that little girl doing?
Well, we're making progress, man. I'm
That's
gonna
all
be
we can
positive
ask
about
for.
it. Yeah,
Amen,
it's all
brother.
good. Yeah, just got to get some reinforcements in here. You know, they got lost in the land of bureaucracy, I think. Like I said. So
I think we've all been victimized by bureaucracy.
let me tell you something, man. I'm not a fan.
All right. This is cause number CR 1964, State of Texas versus Anitria Janae Porter. Ms. Porter, if you will, raise your right hand. I'm going to place you under oath. Ms. Porter, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? I'm sorry, I'm going to prompt you to unmute. If you see that button that says unmute, will you just click that for me? All right. So do you swear to tell the truth today, Ms. Porter?
Yes, sir.
All right, and you understand you're under oath. Okay, you can put your hand down. All right, so Ms. Porter, I know we've had this conversation before. You're kind of soft-spoken. So I know that you're close to that computer. You're in a small office, but I need you to speak up as loud as you can so I can hear you through your mask so that my court reporter who's here with me in the courtroom can take down everything we say, okay?
Yes, sir.
All right, so you're going to be louder than that. All right, so Ms. Porter, you are Zenitria Janae Porter, correct?
Yes, sir.
And are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
ADHD, ADD, and bipolar.
Okay. And are you currently on any kind of medication for any of those three?
No, sir.
And why are you not on medication?
I stopped taking them when I was in high school because like it made me feel like I was zombie and stuff. Like I really couldn't focus like I was supposed to. And then like now that I'm off of them, I can focus a little bit more.
Okay.
Like,
So do you feel like not being on medication anyway makes it difficult for you to understand the proceedings and what's going on in your case?
no, sir.
You feel like you understand everything that you've talked about with Mr.
Yes,
Wood, everything that's happened in court?
Yes, sir.
Okay. And you are represented by your attorney, Mr. Jeff Wood. Are you pleased with his representation of you?
Yes, sir.
Okay. Do you feel like you've had enough time to talk to him about your case and that he's answered all of your legal questions to the point that you understand?
Yes, sir.
All right. Mr. Wood, do you believe your client to be competent today?
I do, Your Honor.
And you've explained to her her legal and constitutional rights?
I have.
So what appears before the court is a proposed plea agreement wherein Ms. Porter will be pleading guilty to a state jail charge of possession of controlled substance in penalty group 1 less than 1 gram. However, it appears that the recommendation is to prosecute this under section 1244B of the Texas Penal Code to the degree of a Class A misdemeanor. And the recommendation is that the court defer a finding of guilt in her case, place her on 18 months community supervision with a $1,500 fine and $180 restitution. In addition, $290 court costs. Is that your understanding? Well, and $785 reimbursement fees to Van Zandt County. Is that your understanding of the plea agreement, Mr. Wood?
That is correct, Your Honor.
All right. And is there anything that I've left out that you're aware of?
No, I believe I think that's a correct depiction of everything.
Okay. So Ms. Porter, is that your understanding of the plea agreement that you've reached with the state?
Yes, sir.
All right, Ms. Porter, the charge of possession of a controlled substance in penalty group 1 is a state jail felony, but the plea agreement in this case would change the range of punishment in your case to that of a Class A misdemeanor. Should you ever be convicted of this offense, the court could assess your punishment up to 365 days in the county jail. So the range is from 0 days to 365 days or 1 year, and a fine not to exceed $4,000. Do you understand that range of punishment?
Yes, sir.
And Ms. Porter, at this time, I'm going to ask you, how do you plead to possessing a controlled substance in penalty group 1 less than 1 gram on or about July 5th of 2018?
Guilty.
Okay. And are you telling me that you're guilty of that charge because you're guilty of committing that charge and you're not just saying that so you can take a plea agreement?
Yes, sir.
And Ms. Porter, has anyone threatened you, forced you, or made you feel like you had to plead guilty to this charge?
No, sir.
All right. The court accepts the defendant's plea of guilt. Mr. Wood, any objection to States 1?
No objection, Your Honor.
States 1 is admitted into evidence. Court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
I'm going to take just a moment, Ms. Porter, here, and I'm going to read just a summary of your case to make sure that the evidence supports your plea today, okay?
Okay.
All right, the court has reviewed the evidence and finds that there is enough evidence to convict Ms. Porter of this offense. The court will follow the recommendation of the state. Court hereby defers a finding of guilt in this matter, places Ms. Porter on deferred community supervision for a period of 18 months, assesses a $1,500 fine, orders her to pay $180 restitution, $290 court cost, and $785 in reimbursement fees. I noticed that in the plea paperwork, in the admonishment section, it said that it was going to be 18 years deferred community supervision.
Yeah, that's wrong, Judge. That's not right.
You don't want to sign your client up for 18 years? Okay.
I think 18 years deferred might be an improper sentence, but nevertheless, yeah, I think months should probably be in there, and that's my fault.
All right. Any objection to the court changing that?
No, Your Honor. Those felony stipulations don't do well for us on reduced.
I lost my touch, Judge.
Now, Ms. Porter, have you ever been on probation before?
No, sir.
You have not? So I'm going to tell you that by approving this and placing you on community supervision, you're going to be required to report to a probation officer. You're going to have to follow all of the conditions of your community supervision, and they're quite lengthy. And you talked to Mr. Wood about what your conditions of community supervision are, haven't you?
Yes, sir.
So do you understand that if you smoke marijuana, you drink alcohol, you go to a bar, you commit another offense that's a Class B misdemeanor or higher, if you don't report, if you don't do something that your probation officer says that you have to do that's in your conditions, if you don't do that and you violate your probation, the probation department is going to notify Ms. Heisel with the state, and the state's going to file a motion to adjudicate you. That means to convict you and to revoke your community supervision. If that happens, then you're going to come back to court. The court's going to listen to the evidence. If I find that you violated your community supervision, the court could revoke your probation and could sentence you up to 1 year in the county jail. You understand that?
Yes, sir.
So I oftentimes tell people this because it's true, that being on probation is much harder than sitting in a jail cell. Being on probation means you have to be mature, you have to be an adult, you have to handle your business, you have to pay your fines and your fees, and you got to be at places on time, and you have to be a productive, lawful, abiding citizen. Otherwise, going to jail is easy. We put you in the clothes we want you to wear, we stick you in a cell, and you go to the bathroom when we tell you, you eat when we tell you, you go to sleep when we tell you, much like being a child. You understand that? And I think we all agree that it's easier to be a child than an adult. Okay. So that's what you get to decide. Are you going to be an adult or are you going to be a child? And if you're going to be a child, then, I'm going to have to put you in the jail and up to a year. And I don't think that's going to be good for you. It's not going to be good for our jail either. You understand?
Yes, sir.
All right. So that's the only speech I'm going to give you. I'm not going to lecture you the next time you're here. The next time you're before me and they tell me you've done something wrong and violated your community supervision, it's going to be time just to do your end of the deal. I'm upholding my end of the deal by putting you on probation. If you violate it, then you're going to have to uphold your end of the deal, which means going to jail. Okay? All right, Ms. Porter, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department. And I'm going to have you report to the probation department. If you'll just have a seat in the hallway, I'm going to have a member of the probation department come and give you more information on what you need to do next. Okay. So just have a seat in the hallway.
Thank you.
Thank you. Anything else, Mr. Wood?
Nothing further on her case, Your Honor.
Thank you, Mr. Wood. Okay.
And Judge, Mr. Woodwike asked me to let you know that he is in the waiting room and he is anxious to be let in on the fun.
Okay. I'll get to him in just a minute. I'm gonna sign this paperwork and talk with the probation. Be right back. All right, Mr. Wood, if you're ready, I will bring Mr. Connor in.
We're ready, Jeff.
All right, good morning, Mr. Connor. Can you see and hear me okay?
Yes, sir.
All right, and can you see and hear Mr. Wood?
I don't see him, no, sir.
Okay, you may have to move left or right on your device to get more. If you want to see Mr. Wood, he's here. Mr. Wood, you can see your client, correct?
I can, Your Honor. I had a brief conversation with him
Yeah, I see him.
in a breakout room before this.
Okay. All right, court calls CR 20-109, State versus Kyle Stephen Connor. We were set for a docket call today. Any announcement, Mr. Wood?
Judge, this case, Mr. Cox and I have been working on this case for some time, and obviously he's gone now, and I was distracted with other things. We had a tentative agreement kind of in place, and then obviously Mr. Woodwike has taken over, I believe, the case. And so kind of starting back at scratch just a little bit, not starting back at scratch, but just kind of getting Mr. Woodwike up to par on the things that we talked about. One of the things, though, that is at issue here is that part of what we were discussing involved the co-defendant in this case. And the co-defendant in this case currently is on the run, from my understanding. Or I don't know about on the run, but hadn't shown up to court. So if we could get another month on this matter, I think that Mr. Woodwike and I could probably figure out how we're going to move forward in a reasonable manner, I believe.
Any objection from the state?
Judge, I heard about a quarter of that. I do believe that what Mr. Wood is saying is reflective of our conversations. I have spoken to Mr. Cox, who is handling this before, but it is my understanding that his offer was contingent on the co-defendant resolving her case. And without doing that, we're going to have to go back to the drawing board and figure something else out for this defendant.
All right, this is the first setting for docket call, so the court will grant your request, Mr. Wood. We will set Mr. Connor for an additional docket call on March 11th. 11th, I will want to hear whether or not we're going to accept a plea agreement or just put it towards trial docket.
Okay, Judge, thank you.
All right, so Mr. Connor, March 11th at 9 a.m., you will appear via Zoom unless you're otherwise instructed by the court or your attorney, okay?
Yes, sir.
All right, make sure that, are you on your conditions of pretrial community supervision? Are you reporting and doing the things you're supposed to be doing?
Yes, sir.
All right, keep that up and we'll see you on March 11th.
Okay. Thank you, sir.
Mr. Wood, is that all you have until this afternoon?
Judge, it is, and I sent you a message regarding Mr. Bruner for this afternoon. I don't know if you received it or not.
I don't. I usually don't have time to check on these.
Sure.
I can look at it, but.
Well, basically, Judge, on Tuesday, I was able to go see Mr. Bruner in jail, and I was it confirmed my suspicions due to his prior mental issues. My worry was that I wasn't going to be able to effectively communicate with him, and that's the case. So I'm going to be filing a motion to have him evaluated for competency, and I anticipate doing that today. I talked to him about it. He understands it the best he can anyways. So I didn't know if the court wanted me just to make that announcement right now or to avoid to have a hearing this afternoon would be my preference, but.
So you've already talked to him and he understands that you're going to file for competency?
That's correct, Judge. I talked to him on Tuesday.
All right, I'm going to set this for a status on the motion for competency. We'll set that on March 11th. But I would ask you file that as soon as you can so that if he is suffering from mental illness, we can get that addressed and get him evaluated in enough time before March 11th. And I would ask that you support your motion with a specific affidavit in accordance with the code that lays out the grounds.
Sure.
Why he should be evaluated. And so we will not pull him in this afternoon on the basis of your statement that you've already spoken with him and that he's aware that he will not, that he will be evaluated for competency, or that the court will be at least considering that as a motion.
Sure.
State have any opposition to that?
No, Your Honor.
Okay. All right. So we'll take him off the afternoon docket. And if you have any conversations with him, you let him know that he'll be set on March 11th.
Okay, Judge, and I'll convey that message to him and get that motion filed with the supporting affidavit as soon as possible.
Thank you, sir.
All right, Judge. Great to see you guys.
Good to see you. All right. Good morning, Mr. Sanders. Can you see and hear me okay?
Yes, Your Honor, we can.
Okay. All right. This is in cause number CR 253, State of Texas versus Joshua Daniel Key. The court has set this on today's docket because the court had received information from the pretrial release supervision officer that there was non-compliance with the GPS device that was a condition of Mr. Key's bond. And I believe that the state has filed a motion to increase bond in this case. Is that correct, Mr. Woodwhite?
That is correct, Your Honor.
Has that been provided to Mr. Sanders?
Judge, I attempted to e-file and e-serve Mr. Sanders. It sort of appears that there was some technical glitch with that. I can email Mr. Sanders a copy if it's not been provided to him at this time.
And Judge, I was aware that such a motion had been filed concerning Mr. Key's situation.
And have you had an opportunity to speak with your client at all, Mr. Sanders, about this issue? Do you need
Yes, Judge, we have.
additional time at all?
Well, Judge, actually, what I was going to ask for, if I know Mr. Waddell is over here, and we've talked this morning too about getting the GPS monitor charged and making sure that he's doing it properly. Judge, I was going to ask if we could get that squared away, if it would be possible to, since Mr. Key has a court date on the 9th of February anyway, if it might be possible to reset these issues to the 9th as well, to see if we can get all these problems squared away with the GPS monitor. And also, when we've been talking this morning, I think we've had some issues with making sure he's gotten his medication. And so that's what I was going to spend some time this morning with Mr. Key to try to get that squared away. Because I think that's been maybe an issue as well.
Have you talked with Mr. Waddell this morning about the GPS device?
Yes, and I think he was having somebody from probation come over here with the charger so that we could hopefully get the monitor charged.
That's the concern that I have from the court, is that Mr. Key is to be on a GPS device, because I found that the nature and circumstances of his arrest are quite concerning, and quite frankly, that was one of the things that gave me peace of mind, is that I would know where Mr. Key is. And now that if he's taking that out of my hand, I'm very concerned again about the safety of our community with Mr. Key in it. If he's not going to charge a device, if he's not going to take his mental health medications, that's not a good recipe in the court's eye.
And Judge, would it work? And I'm not sure what else, how many other cases you have on the docket. I was going to say, would it work if we recess things for a few minutes to see if Mr. Waddell, if we can get the monitor charged, and to talk about that, to make sure that's clear with Mr. Key. And then I was going to check with the jail about his prescriptions, because at least from talking with Mr. Key, I don't know that when he got out of jail that he got the list of prescriptions that the meds he was supposed to be taking in order to even take that next step to get to go to the pharmacy to get the medication.
Well, we can certainly give it a few minutes to try to resolve the issues, but wouldn't Mr. Key and his family know what medications he's supposed to be on without having the jail? I mean, he's
My family's not, unless it's bigger than my family.
Well, Judge, and that's part of the issue too, is that he's not supposed to have any contact with his family, with his parents. And so I think that's been part of the problem too, in not having, there's an individual who I believe is friends with the family who was trying to kind of help him out. But I think probably one of the problems that has been since his mom hadn't been able to have any contact with him, there hasn't been that person to really make sure he got the proper medication to kind of get things squared away from the start, to where we could maybe make this a successful thing.
Okay, so let's do this. I'll let you stand in recess, and then you can let me know when you're ready. Speak with Mr. Waddell, and what I'm going to want today is to feel very confident that Mr. Key understands that the GPS device must be charged. It must be active. My supervision officer needs to know exactly where he's at and when he's there. And the way we can do that is through that GPS device. I need to be assured that he's taking care of his mental health and taking his medications. If either one of those I don't feel good about, then I'm going to find his bond insufficient.
Okay.
I want to give Mr. Key that knowledge before we come back and continue this hearing.
Okay.
So we'll stand in recess on your hearing. I'll put you in a breakout room and leave you there. Actually, you know what? I'll tell you what, just, I'll put this back in the waiting room and we may need to utilize this device again. And then you just let Ms. Abraham know, and get logged back in, and then I'll bring you back in for the hearing.
Okay. Okay, that'd be fine, Judge. Thank you.
Thank you, Mr. Sanders.
Thank you, Mr. Thank you, Your Honor.
You're welcome. Mr. Schmidt, can you hear me?
Yes, sir.
All right, Mr. Tanner, can you hear me? Mr. Tanner? Mr. Schmidt, Mr. Tanner doesn't seem to be connected to audio. I may have to put y'all in a breakout room and let you get that resolved for me.
Yes, sir.
All right, I'm going to move you over to the attorney-client room.
All right, thank you.
Bailiff, who do we have in the jail court?
We have Mr. Martin, Mr. Johnson, and Mr. Eden with us right now.
All right. Try to bring Miss Mellentree in.
Yes, sir.
Mr. Johnson.
Mr. Johnson, come on up, sir. We'll be optimistic. Just stay right here.
Good morning, Ms. Melantree. Can you see and hear me okay?
Yes, I can, Your Honor. Happy New Year.
Happy New Year. All right, this is cause number CR 1920, State versus Gerald Bernard Johnson. I believe that my docket says we're set for status.
Yes, we are, Your Honor. At the time of when we received this status report, Mr. Johnson was out on, well, he was out. The warrant had been issued for his arrest. He got arrested. I had opportunity to visit with him. And I've been communicating with the prosecutor, Ms. Haskell. I want to ask the court if the court does not mind sending me to a breakout room. I just got an offer from Ms. Haskell yesterday, and I need to tell my client about the offer.
Okay, yes, I'll do that right now.
Thank you.
Deputy McLeish, I'm going to prompt you to join Ms. Melantree. So you should get a prompt if you'll just accept that. And then whenever they're finished, then I can bring you back in.
Yes, sir.
Thank you.
You're welcome. Give me just one moment here.
Thank you, Your Honor.
You're very welcome. Okay. All right. So we were set for status. I think we were on the trial docket, were we not?
We were on the trial docket, if I'm not mistaken, Your Honor. And then when he got arrested, you put us on the status. However, I did receive an offer. I just spoke to Mr. Johnson. He accepts that offer. I believe have my plea papers been sent to me, Ms. Haskell?
Yes, I emailed them yesterday afternoon to you.
Okay, yesterday evening,
Yes.
afternoon. Okay. Well, Your Honor, if you don't mind, I need to get those plea papers done and get over to Van County. Have Mr. Johnson sign them. My schedule today, I have a hearing at 10:30, but I know I get out at 10:30. It's going to be short. I can make my way over to Van Zandt County, have him fill out the paperwork and get them to the court.
Okay. So you want to try to do it this afternoon, late this afternoon?
If you say, Your Honor, because I think you said at 1:30, and that gives me ample time to get over there and I can get it done. And by 1:30, I'll be ready to plea him.
Okay. I believe we'll probably resume around 2 today because I have a dental appointment for my daughter. So yes, if you can be here at 2 p.m. and later till 5, then we can get the plea done this afternoon.
Well, let's say, can I say about, can we say 4? Do you want me to come over there? Or do I still do a Zoom or what?
Well, you're going to have to get Mr. Johnson to fill out the paperwork and go over him with that. I don't know how you would do that without being here. What you could do is you could come over and you could appear at the jail to conduct the paperwork, explain that to him, and then you could appear at the jail with him.
Okay, that's what I'll do, Your Honor. I'll get it done. Thank you.
Okay. All right. So you want to say 4? How about we say 3 o'clock and then
3 o'clock? Okay, that'll be fine.
Okay. All right. So Deputy McLeish, if you're not available, if you'll pass the information along, that we'll just have Mr. Johnson come back and visit us at 3 to conduct his plea.
Yes, sir. And I do anticipate being here this afternoon, so we'll take care of it.
All right. Thank you, Mel.
All right, Mr.
Thank you, Ms. Military.
Yes, Your Honor.
Mr. Martin, if you'll step up, please. Joshua Mack Martin.
Hi, Your Honor.
Mr. Steele, a jacket you could put on for me?
Yeah, I'm sorry, Judge. We got 3 Zooms going at the same time.
I heard. I'll make this one quick. This is
Okay.
CR 19-180, State versus Joshua Mack Martin. And we were set today on he's in custody on a motion to revoke. And we set for status of hiring an attorney. And Mr. Steele, you've been retained in this case, correct? And you filed a notice of appearance, correct?
Yes, Judge. And I've been retained on the motion to revoke and on the new case.
Okay, good. So for the purposes of today's hearing, that's the only announcement that I need. Is there any other issue other than setting him for an additional
Judge,
hearing?
I filed, and I haven't had a chance to talk to Tyler. Every county does things differently, but I filed a motion to set bond on the probation violation. Is that something that I need to set for a formal hearing, or is that something I discuss informally with the state? Or how do y'all like to handle that?
The answer is yes. If you agree with the state, then you could send an order over and the court would consider that. If the state does not agree, then we could set it for a formal hearing, and then you can make your argument.
Yes, sir.
Judge, if we could set this for a hearing at the court's earliest convenience, I will get with Mr. Steele and we can discuss this case. If we can reach agreement beforehand, then we will forward to the court the proper paperwork. If not, we'll have a hearing at the court's earliest convenience. I think that's the best way to handle it at this point.
Okay, so what I'll do, I think my next available day that I have enough time and availability on the docket is going to be February 11th. So that's going to be 2 weeks. It'll be 2 weeks from today, if I'm correct.
And that actually happens to be his first appearance on the new case.
Okay, so we'll just put it on that date. If y'all come to an agreement on bail and bond before then you can send over an agreed order and the court will consider that.
Thank you, Judge.
Yes, Judge.
All right, so we're going to set this for February 11th on his MTR at 9 a.m. Or actually, if he's in custody, it'd be 1:30. If he's on bail, it'll be at 9.
Thank you, Judge.
All right, thank you, Mr. Steele. I appreciate you, sir.
Thank you. Have a good day.
You too. Deputy McLeish, are you in the jail court?
Yes, Your Honor.
Who is our third inmate?
We have Mr. Cody Eden with us.
I don't have Mr. Let's see, page 2. Okay, we don't need Mr. Eden. Mr. Sanders filed a waiver of arraignment, and so his next court setting is March 11th for pretrial. And the court signed that yesterday. So he is good to go. He's been arraigned and he's already had his next court date set.
Okay, very good. And Your Honor, do we have any information on Mr. Nathan Sampson from Mr. Murleader?
Mr. Murleader has Zoom. He's logged back in. Let me bring him in and we'll ask.
Okay.
Mr. Murleader, the eye in the sky is spying you. Mr. Murleader.
Good morning again, Judge. I did contact Miss Donna Featherston, and she said that she'd be available in about half an hour. That was about half an hour ago. Do you see her in your waiting room at all?
I think I do. She's not logged in by name, but I did bring in that individual and saw that it was a white female, maybe middle-aged lady.
That's correct, Your Honor.
Okay. All right. So I do have her. Do you need to talk with her? I can put you in a breakout room before the testimony. Do you want to talk to her at all?
No, I already spoke to her, Your Honor.
Okay. Hang on just one moment.
Yes, Judge.
All right, Deputy McLeish, can you bring Mr. Sampson up, put him in a chair or something up there?
He is not physically in the room yet, Your Honor. They're gonna work on bringing him up and,
Okay.
Mr. Wilson too. We need a few minutes.
Okay, yes, ma'am. All right. Well, as soon as you can do that, then we'll go ahead with his case, Mr. Murray.
Thank you, sir.
You're welcome.
I'm sorry, Mr. Eden, what was your question? Visit with your attorney. I kind of have an idea, but if I try to explain it to you, I might.
Mr. Murray, what is this witness's name so I can put her name on the screen?
It is Donna Turner, D-O-N-A, and then Turner spelled, yes. It was with one N, but
One in. I'm asking her to turn on her audio, so that's why you may see her going in and out. I think she's attempting to help us out.
okay. I believe this is the first time that she has used Zoom, Judge, but she has used like video teleconferencing before.
I'm going to put you and she in a room and maybe you can help her work through that. And I'm going to pick up another matter real quick. This will be just a moment.
Your Honor,
Yes, ma'am.
because Mr. Sampson is a bit of a deviation from this written schedule, it's going to take them just a few more minutes to get him up.
That's fine.
We do have Mr. Wilson here.
Okay. And I do not see Mr. Wilson's attorney. So just leave him where he is and I will have my coordinator contact Mr. Stevens and find out if he's joining us this morning.
Thank you, Your Honor.
All right. Thank you. I'm going to mute you. Okay. Ms. Tabraham, will you notify me and let me know if Mr. Bill Stevens is going to join us today for Mr. William Andrew Wilson the third? We're set for pre-trial on all three of his cases.
Yes, sir, I will.
Thank you, ma'am.
All right, Ms. Turner, can you hear me okay?
Yes, sir.
All right, let's keep the phone down and just wait for the judge to call our case, okay?
Okay.
All right.
This is too modern, too high tech for me.
Yeah, just hang tight, okay? If you have a
Okay.
phone, if you have a charging cord, you might want to plug it up to your phone just in case, make sure it doesn't lose battery.
Okay.
I'll be right back whenever the judge comes back, okay?
Okay.
All right, jail court, do we have Mr. Sampson available for Mr. Murleader? And Deputy, I understand that Mr. Stevens is not present in the room, correct?
Sorry, Your Honor. No, sir, Mr. Stevens is present.
Oh, Mr. Bill Stevens is present?
Yes, Your Honor, he is here.
All right, well, I'm sorry, Mr. Sampson, just have a seat. I'm sorry. I didn't know Mr. Stevens was there. Let me go ahead and call Mr. Stevens because I think his hearing will be quicker.
Mr. Sampson, if you want to just have a seat on one of the tall chairs, whatever's easier for you.
All right, Mr. Stevens, this is cause number CR 18-521-522 and CR 19-327, State versus William Andrew Wilson III. And we're set for pretrial in each one of these. Do you have any announcements as to any contested pretrial motions?
Well, first, Your Honor, I apologize for the way I'm dressed. I really thought I was going to be on Zoom at 1:30 this afternoon. So that's why I'm dressed like I am. So I apologize.
Okay. That's okay. That's okay.
Judge, I don't have all the discovery yet. I've been out for 3 weeks with the COVID. I just got back to work, checked the computer yesterday, and I don't have any of the discovery. And I'm sure it was just an oversight because the last time I was in court was like back in December, and I guess December the 3rd, we were over here at court, and I had mentioned it, I think, to Danny, and said they'd get it to me, and I didn't really follow up right at that time. But I don't have my discovery, Judge.
State, can you look into that for me right now?
Yes, Judge. We still have Mr. Robert Perkins as the attorney of records. I will get that switched to Mr. Stevens, and we will get that sent to him ASAP.
And Mr. Stevens, I believe you've been appointed, correct?
Yes, sir.
All right. So the court's going to reset then Mr. Wilson for pretrial hearing on March 11th. And that will be at 1:30 if he's in custody, Mr. Stevens.
I suspect he will be, Your Honor.
The reason is at 9 today is because this was a contested docket day. So, and I just asked the court or asked the state to make sure that discovery is accessible to Mr. Stevens beginning today. And then Mr. Stevens, if you need any of the digital discovery, I believe the burden request that. So once you look in there, make that request to the state if you want that.
Yes, sir, I will.
Judge, I will get it set over today.
All right. Are there any other issues, Mr. Stevens, that we need to take up?
No, Your Honor, not that I'm aware of at this time.
Okay.
Is that it, Judge?
That's all.
Thank you, Judge.
Mr. Stevens, I'll take that hard copy.
Okay.
Thank you.
Just one moment here.
You heard our next court date, okay? We'll be visiting with the prosecutors over the next week or two. I'll be back to see you, give you an update. Maybe we make some progress, okay? All right, you're welcome.
All right, Mr. Murleader, are you ready to proceed on Mr. Sampson?
That's correct, Your Honor. If it's okay, Your Honor, I'll ask Mr. Sampson to sit because he has medical issues.
Yes, Deputy McLeish, if you can provide him a chair.
Watch where you are, but just have a seat behind you, sir.
All right, this is with regards to cause number WR 21-4. This is State of Texas versus Nathan Sampson. And Mr. Murleader, you're requesting that the court set a personal recognizance bond in this matter today. Is that correct?
That's correct, Your Honor.
All right. And do you want to call any witnesses to testify?
Yes, Judge. We call Miss Donna Turner.
All right. Ms. Turner, can you see and hear the court okay?
Yes, sir.
All right. Thank you, Ms. Turner. Can you raise your right hand for me so I can place you under oath? Ms. Turner, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Ms. Turner, you can put your hand down. I'm going to give you a couple of instructions. Ms. Turner, please at all times, make sure you speak up loudly and clearly. Make sure that you stay in the view of the camera so that we can see your face clearly. We are taking down a transcript and record of everything that's said today. So when Mr. Murleader is asking questions, let him finish his question before you answer. He's going to extend you the same courtesy so that we're not talking over one another. So my court reporter knows who's saying what, okay?
Okay.
All right. And all of your responses, there may be a little bit of a lag time, so you may have to wait for that. And just make sure that all of your responses are auditory, yes or no, so that we can take that down, okay?
Yes, sir.
All right, go ahead, Mr. Murleader.
Thank you, Your Honor. Ms. Turner, can you please state your full name and spell it for the record?
It's Donna Featherston Turner. First name is Donna. Featherston is Featherston. Turner Turner.
Thank you, ma'am. And what is your relationship to Mr. Sampson?
Landlord, good friend, that kind of thing.
Are you also his power of attorney?
Oh, yes, sir. I am power of attorney. Yes, sir.
And how long have you been his power of attorney, ma'am?
Probably a month or two, couple months at least.
Okay. Where do you currently live?
I live in Van, Texas on Highway 110.
How long has Mr. Sampson been your tenant in Van, Texas?
About 3-4 years, probably about 4 years.
And what kind of property does he live on? And describe his house or whatever he lives on.
He lives in a little travel trailer on the back on my back property in the corner.
Okay, so he lives on a travel trailer on your property, is that right?
Yes, sir.
How much does he pay you for living in that trailer?
Usually it's whatever he can afford at the time. Usually it's like $100, $200.
Okay. And does he also do like odd end kind of jobs for you, like a handyman?
Yes, sir. Yes, sir, he does.
Does he also take care of your property?
Yes, sir.
And what kind of stuff does he do to take care of your property and your house?
He fixes my roof. I had my roof, the ceiling had fell in one of the rooms and he fixed that. Doing siding on the house because it's a real old house. He mows the yard, keeps it contained, and that kind of stuff. Yeah.
How old are you, ma'am?
56.
Are you currently working anywhere?
Yes, sir, I am.
Where do you currently work, ma'am?
I work in town here in Van at the Dinner Bell.
What do you do there?
I'm a cook.
Do you have any medical issues yourself, ma'am?
Yes, sir. I'm diabetic, high blood pressure.
Does he help you at all with your medical issues?
No, I pretty much contain that myself.
Okay, we're asking the judge today to release Mr. Sampson on what's called a personal bond or release him on a lowered bond, if he is released and the judge imposes conditions of reporting to pretrial probation, would you be able to provide transportation for him?
Yes, sir.
Does he have transportation himself?
It's a motorcycle.
Okay. But if he needed you to transport him, you would be able to transport him?
Yes, sir.
Okay. And you would also be his power of attorney for any kind of issues that might come up. Is that right?
Yes, sir.
How long have you known Mr. Sampson?
About 6, 7 years.
Okay. You know that he's arrested on what's called possession or promotion of lewd visual material depicting a child?
Yes, sir.
All right. I explained that to you that this is a state jail felony offense, punishable by 6 months to 24 months. Is that right?
Yes, sir.
Do you have any idea of his previous criminal record?
Sorta. I know for like drug paraphernalia and speeding, you know.
Do you know if he has any previous felony convictions?
No, I don't.
Do you know what his income is from?
He gets disability.
From Social Security, is that right?
Yes, sir.
And how much does he get per month from Social Security?
A little less than $1,000. About 982.
Does he have any assets that he owns right now?
He has a truck out here, but it's not working. He's got his bike and then his trailer.
Okay. Have you attempted, I'll back up. Do you understand that his bond is currently set at $150,000?
Yes, sir.
Have you or him been able to pay that bond of $150,000?
No, sir.
If the bond was lowered to say $20,000 or $30,000, is there any way that you would be able to contact a bondsman to try to get that paid?
Because right now he has like $1,000 right now.
Okay, and you're managing his finances too, is that right?
Yes, sir.
And you're saying that in his checking account, he currently has $1,000?
Yeah, about 1,000, maybe $1,100. You know, that's about all.
What other bills does he have to pay?
I know in utilities he pays me, you know, but he hasn't been here. Nothing else that I know of, except his phone bill, his cell phone bill.
And how much would that be?
About $139 maybe.
Do you know if he's working anywhere else, Ms. Turner?
No, sir. No, sir.
Is that because of his disabilities?
Yes.
Can you describe what his medical issues are?
I know he's got a heart murmur. He's got clots probably in his legs. that reason why they swell up and let's see. I know there's something else, but I cannot remember what it is. But anyhow, that's all right there. And he's got, blood pressure.
And you were the one who sent me a list of his medications. Is that right?
Yes, sir.
And I've attached those medications to the petition. These medications include hydroxychloroquine. Does he have some kind of a liver or cirrhosis problem?
I believe so. Yes, sir.
Are you aware of any rheumatoid arthritis that he has with neuropathy?
Yes, sir.
Has he complained to you about medical issues that are not being treated by the jail?
Not well. Yes and no. Yes and no. He does.
Can you explain what that means?
He needs to see a doctor, and he said when he puts in a request, he doesn't get that.
So you've been on regular contact with him in the jail, is that right?
Yes, sir.
And prior to being incarcerated in jail, Mr. Sampson went to regular meetings with the doctor's office, is that right?
Yes.
Did he see one doctor or did he see like several doctors?
Inside the jail there?
Before the jail.
Yes, he has several doctors.
Ms. Turner, if he is released on pretrial conditions, do you believe that, do you have any indication that he would run away or try to abscond from Van, Texas at all?
No, I don't think he will.
All right. All right, thank you, ma'am. I'll pass the witness, Judge.
Any questions from the state?
No, Your Honor, the state has no questions for this witness.
Any additional witnesses or testimony, Mr. Merleader?
Just briefly with Mr. Sampson, just for the limited purposes of the writ, Your Honor.
Mr. Sampson, just where you're sitting, if you'll raise your right hand. Mr. Sampson, do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Go ahead, Mr. Merleader.
Thank you, Your Honor. Mr. Sampson, can you hear me okay?
Yes, sir.
All right, Mr. Sampson, you're gonna have to speak up for the court reporter, okay?
Okay.
Mr. Sampson, do you understand that you're currently arrested for the state jail felony of possession, promotion, lewd visual material?
Yes, yes, sir.
When were you arrested for that?
October 28th.
Okay, and have you been in the jail for 90 days already? Is today the 91st day?
Yes, sir.
Okay. And are you aware of any indictment that has been filed in your case?
Yes, sir.
There has been an indictment filed in your case?
Excuse me?
Did you receive an indictment in your case at all?
I haven't received anything, no. I just figured, I don't know. I haven't received anything though, no.
Okay, I explained to you yesterday when I met with you that the state has not indicted you, but plans on indicting you for possession of child pornography. Did I explain that to you?
Right.
What was your answer, sir?
Excuse me?
Did I explain to you yesterday that the state plans on indicting you for possession of child pornography?
That's what you said yesterday, yeah.
And I explained to you that's currently a third-degree felony, right?
Right.
And I explained to you, I don't know how many counts that they're possibly indicting you for that, right?
Right.
I explained to you also that the judge has the option of releasing you on a personal bond on a reduced bond or denying our motion, right?
Yes, sir.
Okay, and I explained to you that your criminal record may be part of that equation, correct?
Yes, sir.
What kind of a criminal record do you have? What felony convictions, what misdemeanor convictions do you have?
It's unlawful attainment 20 years ago or so.
You were convicted of unlawful detaining?
Right, unlawful attainment, yes.
Were you ever sent to TDCJ?
No, I was sentenced to 5 years probation.
Do you remember if that was deferred probation or adjudicated probation?
At the time, I was, from what I understood, it was supposed to have been deferred probation. I don't know what the records show.
Okay. Mr. Sampson, you heard Ms. Turner's testimony about your assets, right?
Excuse me?
Did you hear Ms. Turner's testimony about your assets?
Right.
She stated that you have a bike, a truck that's not working, and a trailer, and a checking account that approximately has $1,100 in it. Is that approximately how much money you have in your account, and is that a fair description of your assets?
If that's what she says, that's in the account, then that's what it is. I don't have access. She takes care of all that for me, so I have no reason to doubt her.
Okay. And you also heard testimony that she has been your landlord for about 3 or 4 years. Is that correct?
Yeah, about 4 years, yes, sir.
Okay. What kind of a job have you had before you came into jail?
Actually, I used to take care of the ladies' lake property, but I was a cabinet builder in Van for 4.5 years, and a machinist in Van for, I don't know, a year or two. And then I worked at the hotel back when it was Holiday Inn Express here in Canton. I worked there. I've been here for 20 years.
Okay. And what kind of jobs do you do for Ms. Turner when you're on her property?
I try to reconstruct her old house back, sheetrock and tape the bed and the roof, the plumbing. We've had several issues on plumbing that I've had to climb up under the house and fix. I take care of her yard, the lawnmower, and sometimes even have to work on her truck, so that way she don't have to take things to the shop. And I mean, old trees that are falling down, trying to, fall on her house, and I try to keep just the whole yard and house maintained as best as I could by myself.
Okay. And is anybody maintaining her yard right now that you know of?
Excuse me now?
Has anybody else been working on her property and maintaining her yard right now?
No.
Mr. Sampson, can you please describe your medical issues?
I have a heartburn. I have issues with, fainting spells and things that even the doctor here says I need to have a procedure done within the next 2 years, which I already knew that was coming, but I have stage 4 cirrhosis of the liver. I have severe rheumatoid arthritis with neuropathy. I have bad circulation in my foot, which is black. That has to do with my heart. I'm blind in my left eye. I'm losing my hearing. I have no teeth left per se. But other than that, I guess I'm doing just fine.
Okay.
Falling apart.
Prior to coming to the jail, were you getting treatment for these medical issues?
Yes, sir.
Where were you getting treatment for these medical issues?
Excuse me?
Where were you getting treatment for these medical issues?
I'm not.
Where were you getting treatment?
What was I taking?
Where?
Oh, getting treated. Oh, I have a primary care doctor I have here in Canton, Ms. Rodriguez, and then I have 3-4 other doctors in Tyler and all through the Mother Francis medical clinics and hospitals.
Do you believe the jail is adequately treating your medical issues?
No.
Why is that?
I've seen the doctor here and he said he was going to give me medication even for my foot. He gave me a water pill. Okay. It's not what I need. I was supposed to have a stress test and a echo done on my heart because I've had some issues with what I thought was either a mild stroke or mild heart attack. And before I could ever get the appointment filled, I ended up in jail.
Okay. Is your current income only from Social Security?
Excuse me? Yeah.
Is what kind of income do you currently get?
Oh, just my disability.
And how much do you get per month?
It's like 970, 980, something like that.
All right, your bond is currently set at $150,000. You know that?
Yes.
Have you made any attempts to try to pay this bond?
No, because I'd have to, even with 10%, I'd have to come up with $15,000. Even 5% would be 75. There's no way I can ever come up with that kind of money.
If your bond was reduced based on your checking account to say the 10% to say $10,000, do you think that you'd be able to bond out?
Yes, I believe I should.
All right. If you are released on bond, whether it's personal bond or surety bond, the judge will impose conditions of reporting to pretrial, or he may do that.
Yes.
Can I explain those conditions to you?
Yes, sir.
If required, can you show up to the pretrial probation office when they ask you to and provide your analyses?
Right. Yes, sir.
And if required, will you be able to make payments for them for both pretrial supervision as well as indigent defense?
Yes, sir.
Do you have transportation yourself to get there, Mr. Sampson?
I do. Both vehicles are broke down right now. It's just there's times I use Donna's truck, but I'm trying to get one of my vehicles were stolen when I was arrested and been parked taken off of, and the other one's been down for 4 years. But I have 2 vehicles. I just need to try to get one of them back up and running again, which.
Okay, if you understand that if you fail to report to pretrial probation, the judge can revoke your bond and put you back in jail because that would be a violation. You understand that?
Yes, I understand that.
So if released, would you make every effort to make sure you report?
Oh, yes.
All right. Thank you, Mr. Sampson. I'll pass the witness, Judge.
Any questions from the state?
Very briefly, Your Honor. Mr. Sampson, I'm sorry, my computer has been cutting out, so I'm sorry if you're repeating yourself. But can you just confirm for the record that you do have a 2002 conviction for unlawful restraint causing serious bodily injury, a third-degree felony?
Yeah.
Okay. And that offense, was that originally charged as an indecency with child by contact, a sexual nature offense?
Yeah. I'm sorry, I couldn't go ahead.
Okay, and then you pled it to the third degree unlawful restraint.
Ms. Heisel, you're,
Originally, that offense was originally sexual in nature and then pled to the lawful restraint.
Ms. Heisel, you were cutting in and out. We're not getting a record on you. Mr. Woodwide, do you want to tag in?
Bodily injury.
Ms. Heisel, you cut out.
I'm so sorry, Judge.
I believe that
Can
Mr.
everybody hear me now?
I can hear you now, yes. I believe that Mr. Sampson testified, his response was yes as to your question about what it was originally charged to and what he pled to.
Okay. Then, Your Honor, I would pass witness and have no further questions for this witness.
Anything further, Mr. Murray, for Mr. Sampson?
Nothing further, Judge, and we rest.
All right. Does the state have any evidence?
Your Honor, the state has no evidence to present, but we would like to reserve for argument.
All right. All right, Mr. Murray, go ahead. You want argument?
Thank you, Judge. Judge, I'll ask the court to take additional notice of the court's file and the petition and its exhibits.
A court will take judicial notice of the file in WR 21-4.
Judge, Mr. Sampson was arrested on or about October 29th. He has been in jail for approximately 91 days now without an indictment in either the charged case of possession or promotion of lewd visual material or possession of child pornography. I would ask the court to just take notice of the fact that this is currently charged as a state jail felony, and without an indictment on anything else, I wouldn't want to speculate as to what the grand jury is going to return. Although you did hear testimony that I explained to him that they might charge him with one or multiple counts of possession of child pornography. As far as Article 17.151 of the Code of Criminal Procedure, it outlines two conditions on which to release an individual on personal bond. And it says he must be released. Number one, it's 90 days incarceration. And number two, it's the state's unreadiness to proceed. And both of those conditions are met, Your Honor. I understand also that we're in a pandemic and the governor has issued dozens of orders. I don't believe any of those orders are operative at this time, Your Honor. Most of those orders were implemented and suspending a few of the codes of criminal procedure in fear that grand juries might not be able to meet and courts might not be able to charge people with offenses. And the operative GA 13 executive order was issued in March 29th, so almost 10 months ago. As of right now, the grand jury in Van Zandt County has met several times since he was arrested, and I believe they could have returned an indictment for him in this case if it was presented. Thus, for that reason, Your Honor, I don't think that any of the executive orders are appropriate. If the court does not wish to release him on personal bond, I would urge the court to set a surety bond of $10,000. You heard testimony about how he is currently unable to afford the $150,000 bond that's currently set. He has deep ties to the community. He works on Ms. Featherston's property. He earns disability, and he would be willing to report as ordered to pretrial if required. So we would ask the court to release him on a lowered bond because we believe that the current bond is excessive, and to set that at $10,000. And with that, we rest, Your Honor. Thank you.
Thank you, Mr. Murray. State.
Thank you, Your Honor. Judge, as you've heard in testimony, Mr. Murray and I have discussed this case. Our office received this case from the arresting agency on January the 13th in our office, and I do have it prepared for presentation to the grand jury tomorrow, which was the first grand jury meeting subsequent to us getting the case, possession of child pornography.
Ms. Heiser, we're losing you again. Give her just a moment and see if she reconnects.
which is higher than what it knows. There is, I don't know that I agree with Mr. Mirror Leader's assessment that Mr. Sampson is entitled to a PR bond. However, given that the case is not indicted within 90 days and he does have significant documented medical issues, the state would not be in opposition to a slight bond reduction. However, we would be in opposition based on the nature of the charge and the evidence that we have reviewed to either a PR bond or a reduction to the level that Mr. Murleader is asking for. We would also ask the court to take into consideration Mr. Sampson's history and the fact that this is not the first time sexually related offense or an offense that is sexual in nature, and that he does have a felony conviction for a offense that involves serious bodily injury. And therefore, Judge, we would ask that if the court does grant him a bond reduction, that it would be only a slight reduction based on Mr. Sampson's history and current offense. And with that, we'd rest and close.
Thank you, Ms. Heisel. Mr. Murleader, do you feel the need to respond at all, or are you fine?
Judge, I'll just point out one thing. Ms. Heisel said that he has a felony conviction. I don't believe that the state has presented any evidence to show that he has a felony conviction. And from what Mr. Sampson testified to, he thought that he was on deferred probation. So I'm not sure if the state has presented that it's a felony conviction. And it's not a crime of violence as the state, or sexual nature as the state is alleging, pleaded to unlawful restraint. And with that, we rest.
And how many days has Mr. Sampson been incarcerated without indictment? Is it 90 days?
No.
Today's the 91st day, Your Honor.
State agrees, 91st day?
Correct, Your
All
Honor.
right, then in review of Article 17-151, the court finds the law to be that the defendant must be released on either a personal bond or by reducing the amount of bail required with no indictment in 90 days for a felony offense. The court finds that Mr. Sampson is arrested on a felony offense, that no indictment has been presented. The court does find that Mr. Sampson does have a financial means of meeting a surety bond if the amount was set, which would allow him to be released. The court is going to set Mr. Sampson's bail at $5,000, with the court's understanding that that should give Mr. Sampson the ability to make a surety bond in this case, and then also provides him additional money left to be able to support himself and pay for his basic necessities. The court is going to also place conditions of pretrial release on Mr. Sampson to report, to pay for his community supervision, and the court is going to customize some conditions that will prevent Mr. Sampson from being around any minor children, and also not being able to have access to any video or photographic capability of any minor children. So the court's going to customize some conditions of pretrial release, and I will sign that order and send those conditions to the jail today. Once Mr. Sampson signs those conditions of pretrial release and posts the surety bond, then he can be released. Mr. Murleader, if Mr. Sampson is unable to post the surety bond, then I'm going to ask that you notify the court for its reconsideration.
Yes, Judge.
Anything further, Mr. Murleader?
Nothing further, Judge. Thank you.
Okay. All right. We'll be adjourned in this matter.
Thank you, Your Honor.
Thank you, Mr. Sampson. All right. Do we have anyone else at the jail that needs attention?
No, Your Honor, I don't believe until this afternoon.
All right. Thank you, Deputy McLeish. I appreciate you so much.
Thank you, Your Honor.
I will see you this afternoon.
Yes, sir. Thank you.
Thank you, Ms. Turner. All right, Mr. Schmidt, you there?
Yes, sir. I'm here.
Okay, I'm going to bring Mr. Tanner in. Attempt 2. Mr. Tanner, are you there? Can you see and hear me? Mr. Schmidt, were you able to get Mr. Tanner's audio video resolved?
We did earlier. His audio was working in the breakout room. There's his video. He bless his heart. His technology is frustrating, but he's there.
I'm prompting him to start his video.
And Judge, as I was trying to explain earlier, he has a very, very unstable internet connection where he's at. Let me see here. I'll try to get him on the phone, but it may be just the internet connection is the issue.
If you can get him on the phone and put him on speakerphone, I just want to be able to admonish him about his failing to appear on Tuesday, and then we can proceed pre-trial.
Okay. Tyler, I know you're trying to, but I'm going to put you on speakerphone in my office. You just stay right where you're at, okay? Mr. Tanner, can you hear me?
Yes, sir.
Judge, can you hear Mr. Tanner?
Yes, I can hear Mr. Tanner. Mr. Tanner, can you hear me? This is Judge Chris Martin.
Can you hear the judge? Can you hear it over my phone is the question. Okay, so you can hear, he can hear you, Judge.
All right, this is cause number CR 2312, State versus Schuyler Matthew Tanner. We were set for pretrial hearing on Tuesday, January 26th. Mr. Tanner did not appear on that date, and so the court is not taking up the pretrial issues, if any. And I need to know, Mr. Schmidt, why Mr. Tanner was not in court as ordered.
Judge, on Tuesday, Mr. Tanner and I were in communication as early as 8:30. He was attempting to get his Zoom thing set up. He was unable to do that based on his location in the county and the lack of actual internet. In addition to that, he had issues with transportation. And I know he made attempts throughout the day, and I was in contact with him throughout the day, trying to get him either set in or here, but he was unable to accomplish that in a timely fashion, and that's why we're here this morning.
All right, Mr. Schmidt, are there any contested pretrial issues with regards to his unlawful of possession of firearm charge?
No, Judge, we've received the discovery and reviewed it, and we have no contested pretrial at this time.
All right, the court's going to see Mr. Tanner then for docket call on March 11th at 9 a.m. And Mr.
Judge,
Schmidt, go ahead.
I'm going to be in your court on several cases on March 9th. Can we set Mr. Tanner on the 9th, or are we booked up that day?
Let me look. I'm afraid we may be booked up, but just give me one moment. No, I think we have just enough room that I can squeeze in another one. So we'll set Mr. Tanner then for March 9th at 9 a.m. And Mr. Schmidt, Mr. Tanner's going to have to figure out a way to appear via Zoom, or if he can get transportation to the courthouse, I can place him in my video conferencing room. But he needs to make an appearance. I need to know that he's taking it serious and that he's reporting and these issues.
Yes, sir. We'll make sure.
So March 9th at 9 a.m. And if he doesn't appear via Zoom that day, the court's going to take his bail and conditions of pretrial release under consideration.
Yes, sir. Thank you. Can we be excused?
Yes, thank you, Mr. Schmidt.
Yes, sir. Have a good day. Did you hear that, Mr. Tanner?
Yes, sir. March 9th at March 9th at 9 a.m.
That's correct. And the court has said that if you do not make it either via Zoom or to the courthouse on the 9th, that you will be revoked. You got it? So you need to figure out what you need to do.